And then,
In the front, I'm sorry.
ma'am, go with the bailiff. Ms. Bork, you're charged with the state jail felony offense of fraudulent use or possession of identifying information from November 1st of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Fabrication.
It's admitted. Is there any evidence that Ms. Bork is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information, sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. All right, good luck to you, ma'am. You can go back with the bailiff. And then,
In the front, I'm sorry.
ma'am, go with the bailiff. Good morning. You're Marcus Elam?
Yes, ma'am.
And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation, on probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
I do.
Are there any additions or corrections to the report?
No, nothing's been changed.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete his probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over, get life, live with my family, go back to work, help my mother died, give her bill, and everything else, Your Honor.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
Well, they should all be.
What happened? So what was the deadly conduct from August of 2023? What was the outcome of or I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
I mean, he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Can you tell?
I'm sorry, Judge, I didn't look him up after he pled through.
I know. I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
His obstruction in 2023 that was dismissed.
Birthday gentleman. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or accused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they would take him.
I think when he had the prior MTRP, I don't know if it was at the new case or a prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation, and I want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, second-degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same day. Regardless of what's come of those cases, you've admitted that something happened on those that day, right?
Mm-hmm.
So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
23. You started this when you were 19. Feel like you're not taking advantage and you're not growing up and making better decisions.
And I think Ms. Isaac tried to work with him when he would show up to work with her. So, I mean, I don't object to revocation, Judge, and any opportunity that we've given him.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again and you violate again and you take off. So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. You are Michelle Lee Cormier, and Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25, DCCR 0153. Mr. Radford has filed, there's a motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder?
Judge, if I may, the common law has established that murder is when someone intentionally, knowingly causes the death.
But the statute is what we're going to go by.
Yes, ma'am.
Okay.
But I don't think it was the intention of the legislature to remove the requisite mens rea,
What makes you think that?
because the common law going back 1,000 years has required murder to be intentionally and knowingly.
But they've added section B4, which it's a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B, blah, blah, blah. That's fentanyl. That's what the allegation is. And so it actually has the mens rea of knowingly deliver. It reads straight from the statute, so I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section, that the actor's conduct in manufacturing or delivering was authorized under chapter 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an exception.
Is it my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says. Did then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling that into her body. So
that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's.
I think
Go ahead.
what Mr. Radford's trying to do is box the court in here.
I'm not gonna.
My interpretation of the statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
It says knowingly to.
knowingly deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think I'm not going to make that decision. That's not
Right.
that's just an element of the offense. So the motion to quash is denied.
Yes, ma'am, I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the statute.
I understand.
I'm going to follow it as written.
Yes, ma'am.
All right, so that's denied. Hold on just a second. Then there's additionally, I don't see an order on that motion.
I didn't know if I said it.
I can.
I got one.
Okay.
So
Did I
that's,
submit? Oh, thank you.
then in addition, I'm just gonna set that right there for now. There's the order. Okay. Mr. Radford has also filed a motion to reduce the bond, which is currently, hold on a second, let me get to all that stuff.
500,000.
Thank you, ma'am. Oh, you filed an application of writ to seek reduction. Currently set at 500,000. Okay. Or do you plan on calling your
ma'am.
client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I mean, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that can't go there at all.
Yes, ma'am. I
Okay.
understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
Yes, sir.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family
Yes.
can help you? Have you talked to your family about possibly helping you with a bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
And you have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont,
Where would you live if you made bond?
the Golden Triangle, Beaumont, or Bader.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Bader. My aunt lives here in Beaumont, off of Major Drive.
If the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for burglary of habitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I'm trying to, I think it's probably in this reply. What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft.
Can I rephrase that?
No, just
Okay.
answer her
Yes,
question.
ma'am.
In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you, in fact, smuggled fentanyl into the
I'm
jail?
going to object to that. I think you said the allegations are what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other fellow inmates?
Again, Judge, I'm going to object. That is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm going to object at this time, Your Honor, to that.
I think any of those are going to go to her Fifth Amendment right against self-incrimination,
Yes,
Mr.
One last
Clement.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. Yes, sir.
That's all I have.
What's the status of that case? Do we
Still
know?
pending as far as I know.
Okay.
I don't think it's been filed. If it's orange, it could
They're
take-
waiting on
It could take
drug
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think 500,000 is adequate based on the nature of all of those matters.
One hearing, 3 very different outcomes, a negotiated plea, a 6-year prison sentence after repeated probation violations, and a denied bond reduction in a fentanyl-related murder case. Today's courtroom proved that every decision carries consequences. Subscribe for more real courtroom breakdowns, and we'll see you in the next case.